confusion?
I stated multiple times on the record that I wish to represent myself.
Well, I thought we got rid of that issue the last.
Yeah, I thought so too. I spoke to this gentleman right here and expressed my wish to represent myself as well.
All right. Well, if he doesn't want you, I mean, we'll figure that out in a moment. So, Mr. Styron, we're going to go through this again. What do we want to do in this case? You understand what you're charged with, sir?
I understand what the charges are against me, yeah.
Okay, look, you're going to have to give me straightforward answers to my questions because I've got to make sure that you understand certain things. I got to do certain things here.
From my understanding,
you understand, first of all, that if you do be direct, you want to smile about it and laugh about it, take him back. We'll call him out later. Take it back. You keep laughing. You laugh one more time, that's 30 days. Go contempt. Look it up.
You may need an attorney.
Your fault. Court calls the case of the People versus Styron. Recall. State your name.
My name is Thomas Styron. Living man.
Mr. Styron, you are before the court. You have elected to represent yourself. I do have to advise you that you have 3 counts against you. First count is that of fleeing and eluding 3rd degree under the Motor Vehicle Code. Do you understand the nature of that charge, sir?
This is under the assumption that you're compelling me to identify as Thomas York Styron, the legal entity on this case?
I believe that you are. Do you understand the nature of the charge, sir?
The courtroom turns tense almost instantly as the defendant insists on representing himself while refusing to answer the judge directly. What begins as a routine exchange quickly spirals when the judge warns him repeatedly about his attitude and laughter in court. Instead of cooperating, the defendant challenges the court's authority and even disputes his own identity connected to the case. The confrontation escalates so fast that deputies are ordered to remove him from the courtroom mid-hearing.
I don't understand how the name you have on the case and who I am, it's 2 different people.
I have a complaint. Thomas Styron II. Do you understand that that individual is charged with fleeing and eluding 3rd degree?
So,
do you understand the nature of that charge? You just need to answer my question.
For the record,
take him back, and when he decides he wants to cooperate, we'll bring him back. Maybe. I'm not threatening you. Say one more word, and that's 30 days. 30 days. Recalls the case, People of the State of Michigan versus Thomas Styron II. Styron, you are before the court on a felony complaint that does allege count 1. And I'm going to presume, since you do not want to answer the court's questions, that you understand English and understand what I'm saying. You are before the court on 3 charges.
After bringing the case back on record, the judge decides to move forward despite the defendant's refusal to cooperate. One by one, serious felony and misdemeanor charges are read aloud, including fleeing police and resisting officers. The judge carefully explains the risks of self-representation, warning that the court will treat him like a licensed attorney without offering legal help. Even then, the defendant interrupts with strange legal claims, showing no sign of backing down.
Count 1 is the charge of fleeing and eluding 3rd degree. Under the Michigan Motor Vehicle Code, that is a felony punishable by up to 5 years incarceration or $1,000 fine plus court costs, and would require the Secretary of State to suspend your license for up to 1 year upon conviction. Count 2 is assaulting, resisting, and obstructing a police officer. That is a felony or high court misdemeanor, punishable by up to 2 years incarceration and or a $2,000 fine plus court costs. Count 3 is a misdemeanor offense of operating with a license suspended, denied, and or revoked. That is a misdemeanor as indicated, punishable by up to 93 days, $500 fine plus court costs. Your vehicle could be subject to immobilization. Since you refused previously to answer my acknowledgement as to whether you understand that, I will assume that you understand what you're charged with. You are also entitled to be represented by counsel at this and all subsequent proceedings. If you cannot afford to hire an attorney would be provided at public expense to represent you in this matter. You are entitled, as indicated, to be represented at this proceeding, all subsequent proceedings, including your preliminary examination, and if the matter were to proceed by trial, would be entitled.
The hearing takes another dramatic turn when the judge confirms the defendant will serve 30 days for contempt after his earlier courtroom behavior. Instead of calming the situation, the sentence triggers another stream of bizarre arguments about trusts, identity, and government authority. The judge's patience visibly fades as he warns the defendant that more punishment is coming if the disruptions continue. The exchange becomes increasingly hostile as both sides speak over each other in open frustration.
You would be entitled to counsel. It is, as we have gone through with the previous proceedings, the court's understanding that you do not wish to be represented by counsel, and that this matter will then proceed forth with you representing yourself. I have to advise you that in representing yourself, the court will make the presumption that you understand the Michigan court rules, those regarding both procedure and those regarding evidence. The court will not be providing any legal assistance to you during the course of those proceedings and will hold you to the same standards that I would hold an attorney representing or practicing before this court. So, with all of that, and with the court's understanding that you do not want to be represented by counsel, I will set this matter for its next proceeding.
You understand I'm the beneficiary, not the trustee, right?
That will be the preliminary examination. I will set the preliminary examination. Has discovery been provided to the defendant?
Your Honor, he was previously represented by the public defender. I don't know if he turned over the paperwork to him.
Does anybody from the public defender's office know whether or not the defendant has been provided discovery? Mr. Odella. Thank you, sir.
Thank you. Your Honor, we have the discovery. I have not been able to share that discovery with Mr. Steyer, and I've tried to speak with him and go over it, but I'd be happy to turn that over to him at first available.
All right. If you would either turn that over to the court officer so that they can provide that to Mr. Steyer so that he has the discovery, and if you could do that today, I would appreciate it.
Yes, Your Honor.
I'm setting the preliminary examination. Thank you, sir.
Yes.
Moments after the contempt dispute, the focus suddenly shifts to the defendant's attorney. The defendant openly rejects his own lawyer in front of the court, claiming the attorney speaks more like a prosecutor than a defense counsel. He repeatedly says he wants anyone else to represent him and refuses further communication with the attorney entirely. As the judge questions him about the conflict, the defendant's complaints reveal a growing distrust of everyone involved in the courtroom.
The people would have their witnesses available June 11th. Set this matter for preliminary examination in person, June 11th, 2024, 9 a.m. That is before me. Defendant, as he was leaving the courtroom the last time, the court did find the defendant in contempt, sentenced him to 30 days. The defendant will serve that sentence. The court will sign the judgment of sentence regarding the contempt.
I don't understand how that's possible. Like I said,
So first of all, watch your language.
You're treating me as if I'm the trustee, or I don't want to partake in any trust fraud or anything like that. Is this a QVA trust matter involved in this? Is my social security number attached to this at all?
Byron, or whoever you wish to be addressed as, I'd suggest that you watch yourself because there's going to be more time coming. You keep it up.
The judge attempts to explain that defense attorneys sometimes challenge their own clients to prepare them for difficult situations in court. But the defendant refuses to accept the explanation, insisting he wants different representation no matter what. In a final sharp remark, the judge points out that the attorney he is rejecting is considered one of the best available. Even with that warning, the defendant stands firm, ending the hearing in the same combative tone that defined the entire courtroom clash. Like the video, subscribe to the channel, and we'll see you in the next video.